has the burden of proof in tax court litigation? Well, this is the reason why 70% of the taxpayers that choose to litigate against the IRS lose. You have the burden of proof. How are you to establish your burden of proof without a tax attorney? If you go pro se, you're not trained in the law, you're not trained in evidence. Frankly, you're fighting David and Goliath, and you're going to lose this time. The Bible's not on your side. However, I'm David and I'm used to taking on Goliath. Unfortunately, 95% of the time, the burden of proof is initially on the taxpayer. Unless the burden of proof is placed on the IRS under tax court rule or by statute. The biggest problem with going pro se against the IRS in tax court is that the IRS notice of deficiency is presumed to be correct. The IRS's determination, as stated in the notice of deficiency, 90-day letter, is presumed to be correct by the tax court, and it's an uphill battle to change that presumption in your favor. It is the taxpayer that bears the burden of proof to prove to the tax court that the IRS is wrong and the taxpayer is right. In cases involving income tax, estate tax, or any other type of tax, the burden of proof may be shifted to the IRS if the following conditions are met. First, you must be able to prove to the tax court that there are sufficient facts in your favor and evidence in your favor to support an assertion that the government could be wrong. Second thing you need to do is prove to the tax court that you kept sufficient records to support your position, to overcome the presumption that your record keeping is a cause of the problem. Third, you need to be able to show sufficient cooperation with IRS requests for information to support your position. Fourth, it helps where you can show the tax court that you're a corporation or a partnership with net worth of $7 million or less.